Let's move to this story. Justice Secretary David Lammy reportedly already seeking to water down controversial plans to scrap jury trials. This is, of course, after a memo containing the proposal was leaked on Tuesday of this week. The planned shake-up could see 95% of jury trials axed and decided by a judge alone, reserving juries for alleged offences holding sentences of more than 5 years. The real serious stuff, murder, manslaughter and rape were the three that were mentioned. Let's speak with Sir Simon Jenkins, author and columnist. Simon, good afternoon to you, sir. As you will already be aware, if I speak to a lawyer or anyone in the legal world, it does appear there is a bit of a consensus that this is the worst idea anyone on planet Earth could ever have. I know you have a slightly more, is it fair to say, a nuanced view or a completely different one?
Yes, I think if you're talking to a barrister, they might say that. I'm not sure all lawyers would say that, I have to say.
Fair point.
But anyway, I mean, getting into proportion, 1% of criminal trials in Britain, 1% go to juries. It's an almost trivial aspect of the judicial system in Britain, but it has this, what I call almost Disney-esque affection, this nostalgia for the Middle Ages. And it keeps coming up. People keep referring back to Magna Carta. It's almost unbelievable. It is a very trivial aspect of the judicial system, but it uses up huge amounts of time and money. And honestly, I've served on juries 3 times. It was a waste of everybody's time, and it should just stop. There's no point in it whatsoever. And the romanticism of barristers about it, because it's afterwards, it's their stage, that's where they do their acting. They want it to go on forever.
Indeed, and yes, there is a sort of an acting. George Carman's name came into my head when you mentioned acting lawyers, because he almost had the Oscar in that respect. So there is something in that, but of course their argument is a little more, it's a little deeper and more intelligent, I would suggest, Simon, than that. They argue that actually when it comes to the details of law, that it's not for a judge to make that decision. That isn't their qualification. It is for your peers to look at the evidence, guided by a judge, of course. And the guidance, if it's good and the judge knows their stuff, and you certainly hope they do, then that will provide a more thorough form of justice via the conduit of your peers, not through just a qualified man in a wig, to coin a phrase.
Well, if you'd met your peers sometimes in a jury room, I'm not sure you'd say that.
Well, that's fair.
I have to say, the exact parallel is in a hospital. If every time you had an operation, you put the decision of the judge of the doctors concerned to a jury in the waiting room outside to decide what operation should have, you'd think that was completely crazy. Now, most justice decisions now are very complicated. They deal with matters of science, the science built into the evidence, matters of the nuance, all sorts of psychological factors as well, which don't get really aired in the kind of robust, I call it a sort of play acting of a courtroom, where you have a person presenting the worst possible case and one other presenting the best possible case. You ask the audience to decide who won. It's a completely crazy way of proceeding. I mean, nowhere else in Europe does it, you know. I mean, we all behave as if the rest of Europe is barbaric. They don't have juries. They don't have juries, so they don't work.
But they never have, and they have different systems, and they don't just have one man or woman sitting there deciding. There is invariably panels that look at these things. Would you be more in favour of something like that?
Yes, I would. I tell you one thing. One of the consequences is that European justice is much fairer than ours. If for no other reason, far fewer people go to prison. We send more people to prison than anywhere else in Western Europe. The only other country that has juries like we have is America. They're crazy about juries, and it's collapsing. It's completely collapsing. 98% of trials now don't even go to court. They're decided in a meeting between a prosecutor counsel and a defence lawyer in front of a judge in private. It's not even open justice. It doesn't. The system does not work, and it's a tiny element in the judicial system anyway. And it doesn't need to go on. It really doesn't.
I mean, you say it's a tiny element. It may well be, but of course, it's the element that deals with the most serious, egregious kind of cases. You know, horrendous acts of killing and rape and assault and robbery. I mean, the worst scenarios one can think in terms of criminality happen in a Crown Court for obvious reasons. So whilst the percentage against, I don't know, you know, Bob who's done for a speeding ticket or something like that in a magistrate's court, or some issue around who looks after the kids every other weekend. I understand there could be different persuasions on that, but the big stuff, the argument also seems to be, Simon, that actually what you get are people who are... The idea that 12 people are not in the judiciary, they're not part of the system, is the very essence of it, that it allows ordinary, quote, ordinary people to have a say on something when given and guided by the evidence.
Well, I repeat, is that how you like an operation in a hospital?
But there's not necessarily an equivalence on that, is there? There are different considerations.
Well, I mean, the famous Channel 4 a jury trial they did last year,
yes,
when they had two juries, and they totally disagreed. But the basis on which they disagreed was kind of almost vacuous. I mean, I've taken part in these. I mean, most of the people in the room don't know what on earth's going on. This is stupid. I'm not in favour of one judge, incidentally. There'd be a judge plus 2 assessors, and you get an appeal against it. It's not as if it's the end of the work, end of the day. To me, justice is about getting facts right and testing them when they're very complicated. This is an expert job, and the idea that it's the one area of the public sector, in a sense, where experts are considered inadequate and idiots not. And I'm amazed it survives at all. And it survives, frankly, because of the fanatical conservatism of the legal profession, that's all.
Well, I'm sure there's something in that. And I guess with something like this was a leaked, quote, leaked memo. You know how these things work. I mean, they're sort of put out there so that people like us chat about it and then they can test the water. David Lammy, I don't think for one moment came up with this as a sort of personal crusade. He previously spoken out very much in favour, and it looks as if, Simon, that this thing will either be watered down or won't happen at all. So we'll be back to the jury system.
Well, it was caused by the Leveson report came out last year.
Yeah.
And there's a very senior judge, a member of the legal profession, I may say, and he came up with an excellent report. Making basically the case I've been made, and he thinks there should be 3 people rather than just one judge judging it. But ultimately, it's about what is the most efficient way of proceeding, and the jury system, or the system in Britain, is just broken down now. You cannot have people waiting for rape trials for 5 years. It's just inexcusable. Now, it may well be partly cost, but it is partly because of the amount of time taken to have a jury trial. It's 3 or 4 days, which needs 2 or 3 hours. It's absolutely crazy. I mean, I like people's affection for old things. I rather like old buildings. But old judicial processes really are out of date.
And it seems, Simon, that when this idea was floated in this leaked memo, it wasn't really about a kind of philosophical shift in what is better, rather a way of getting the waiting list down, which may well be a good thing to get those lists down, but not perhaps done for a very different reason.
Well, I mean, if you simply can't hold a trial because it's got so completely bunged up, it's a good reason for changing it. Yeah. I agree with you. It'd be nice to change it because it's wrong rather than because it costs money. But either way, it really ought to change. The system at the moment is justice denied. I mean, justice delayed is justice denied. And justice at the moment is being denied to thousands of people. It's quite wrong.
Yeah, I think we can all agree on that. Simon, lovely to have you on with us. So we will speak again, I hope. Sir Simon Jenkins, author and columnist, with a very different view, but quite a compelling argument, really. When you look at the numbers that he cited, only 1% of situations legally end up in a court that requires a jury. He believes much of this is the vanity of barristers who love to play to a jury. That's partly what they got into the gig for, so they can showcase their amazing legal brains to 12 good men and women sitting there. And it's, I think, ultimately what Simon was saying is preposterous that the likes of me or you would be in charge of someone's destiny. More likely that it would be something that a legal brain would do. My fear with that, as I was trying to suggest to him about the sort of ordinariness that a punter can bring to it, I think the trouble is with judges and really experienced barristers is that they've done it so long that they can only really see through the prism of the legal bit rather than the human bit. And we had Chris Dorr, the barrister, on yesterday, and he was citing a case that he genuinely felt would not have gone the way it should have done had it been decided just by a judge. But it went to a jury, and the jury were able to kind of see the human side of it and really digest and soak in all of the human implications, which was important. And it is a, kind of a factor. Although often a judge will say, this is not about your emotions, this is about the law. Whereas a judge may just look at something and go, well, legally speaking, whether you like it or don't like, legally speaking, you've actually broken the law. So I can't then go, well, I'm not going to send you to jail because this particular offence carries 2 years in prison. And of course you would say, well, yeah, but what about the human aspect? Look at the terror this person had been put through. Look at what had happened in their life leading up to the offence. There are circumstances that led to this person committing the crime. So that would be the difficulty. But Simon's point was, well, you'd have 2 other judges there as well that would also be assisting on the decision-making process. 034